Hello everyone, my name is Ruth. I am an Australian registered migration agent and a solicitor of the Supreme Court in our state and the High Court of Australia. In this video, I will be sharing on the genuine entrant requirement for employer-sponsored visas. I note that the information on this video is not to be treated as legal advice, but it will provide you with vital information regarding this program. Now, employers who wish to nominate an overseas worker for permanent residency visas must show that there is a genuine need for a worker to fill a certain position on a permanent and ongoing basis. This criterion applies to both the temporary residence transition stream as well as the direct entry stream. In regard to the temporary residence transition stream, since the introduction of the new TSS subclass 482 visa, it has led to this. Unlike previously, there is no longer an automatic right to permanent residency. Even if an employer has worked for the business for a number of years, the employers must still show and prove that there is a genuine need for the worker to remain employed in that position. The Department of Home Affairs will take into consideration the following: to establish that there is a vacancy for the nominated position, and to verify claims that the genuine need arising from temporary work visa, whether it is subclass 457 or TSS visa, actually exist. Immigration can now go back to the previous visa to verify that genuine need actually existed in the previous visa. That is a pretty stringent requirement. Now, it is noted that the evidence of genuine need is not the same as proving evidence of labor market testing. It is a different requirement. So what evidence would the department consider? So here are some of the examples: the length of employment, business structure, industry sector, number of foreign employees employed by the business. Financial annual with increased activity within the business will also be good evidence. And a small business may consider including evidence of expansion, for example, new contracts, projects that has been recently won. I will now move on to the direct entry stream. Now, the threshold for direct entry applications is usually more stringent than the temporary transition stream, as the worker is seen to be untested in the Australian labour market. So let's go through some of the examples of acceptable evidence under this stream. Example 1. If the worker will perform activities that leads or assist with the diversification of the business. For example, a current business is hiring a manager so that they can expand and start a new or purchase another business. Now, the business will need to prove that it has the intention to expand as well as have the financial capacity to support the expansion. The business will also need to undertake market research, provide business plans with a clear vision on intended expansion and timeline, and financial requirements and budgets as evidence of funds. The second example is if there is any diversification in the business. If the business runs a particular service but would like to now diversify or expand into another type of service which complements the current service, in this case, the business must show that it has the capacity and intention to diversify and provide documents such as business plans, financial budgets, availability of business premises, purchase of equipment, and evidence of funding. The following actions may lead a case officer to think that the nominated position may not be genuine. For example, if there's been retrenchment in the previous 12 months, if there's been reduction of hours worked during the previous 12 months, if there's been reduction in pay and conditions within the previous 12 months, if employment of a temporary visa holder on condition is less favorable than those of an Australian employee, or recruitment of temporary visa holders beyond the ordinary scope of the operation of the business. Notwithstanding the above, each case is treated differently. If your business is faced with one of the negative connotations we've just mentioned, it does not mean that the application will be refused. It just means that we will need to work harder with extra submission to strengthen the case with additional evidence. Now, the information in this video is not to be treated as legal advice. It is general information only. We assess each case on a case-by-case basis. With the ever-changing laws of the Australian immigration, it is vital that you obtain updated advice at the time that suits your situation. Now, if you are an Australian employer looking at sponsoring an overseas worker and require advice on how to proceed, please do not hesitate to contact us on the email address below. Thank you, and we wish you the very best.